You look familiar.
I think I'm here.
All right, have at it.
May it please the court, my name is Chris Altenburn. I'm here today from Banker Lopez Gassler representing Gulf Marine Repair Corporation, and I'd like to save 4 minutes for rebuttal. I'd first like to take several minutes to explain why this case has become indistinguishable from this court's decision in Turner versus Hillsborough County Aviation Authority, and that it can be reversed simply because the property appraiser is actually challenging the constitutionality of a statute that he is obligated to obey. This case began because Gulf Marine maintained that its deepwater port marine repair operations were quote unquote maritime or port purposes as defined by the legislature in 1997 for tax years 98 and thereafter, when it created the narrowly crafted deepwater port exemption in section 196.012 subsection 6. The legislature crafted this exemption after the much broader exemption for racetracks and stadiums and tourist attractions had been held unconstitutional by this court in the Sebring Raceway cases that were 2 in this court and 2 in the Supreme Court. It also crafted it after it knew that the Supreme Court would test its statutory exemptions for constitutionality under the so-called governmental versus governmental proprietary dichotomy. And I would point out that after it created the deepwater exemption, that no court has ever held that that statute was unconstitutional, the trial court in this case. GM or Gulf Marine relied on the text of the statutory exemption because it knew that that was all it needed to prove in this case. And the property appraiser understood when this case began that after this court's decision in Turner and the Supreme Court's decision in Fuchs, that a property appraiser can no longer challenge the constitutionality of an exemption in subsection 6, like had been done in the Sebring cases. In Turner versus HCAA, a prior Hillsborough County property appraiser, but represented by Mr. Shepard, challenged the decision of the Value Adjustment Board, which had ruled that the Yankees training field near Tampa Stadium would fit within another exemption in subsection 6. And this court held that the property appraiser had no power to challenge the statute he was obligated to obey. The court held that the property appraiser's effort to say, well, he really wasn't challenging the statute, he was challenging the VAB's ruling, was not an adequate distinction because the ruling was based upon the statute. And the Supreme Court approved that in Fuchs. So when the property appraiser filed his notice of disapproval, both against the Port Authority and Gulf Marine, and then he filed his challenge to the VAB's ruling, in which the VAB had fully explained that Gulf Marine fit within the text of this statute. The property appraiser alleged that Gulf Marine did not fit the statute. He did not allege it was unconstitutional because he couldn't. And when we filed the several protective lawsuits in the subsequent years, alleging that we fit within the specific exemption quoted in subsection 6, he didn't raise an affirmative defense that that subsection was unconstitutional because he knew he couldn't. But what he has done is he has morphed the lawsuit into an action to challenge the constitutionality of the subsection simply without using the word unconstitutional anywhere in his arguments or in his pleadings. The order granting partial summary judgment submitted by the property appraiser to the trial court did not rule that the VAB had violated the due process constitutional rights of the property appraiser, or that the VAB was wrong in its well-reasoned decision that the Gulf Marine fit the statute. Instead, that order says that GM's use of the property must meet the governmental test, and that the operation of the shipyard was not the administration of some phase of government. That's not the statutory language at all. That's the language that was created by the judiciary in Williams and the Sebring Airport cases to determine the constitutionality of a statute enacted by the legislature. The property appraiser is having this court hold that the statute is unconstitutional, just like in Turner, but without using the words unconstitutional. Now, when this proposed order was submitted to the trial court, the property appraiser didn't disclose that Turner and Fuchs were the law and that they clearly prohibited him from making the arguments he was asking the trial court to adopt. We sought rehearing at that point in time, saying that the statutory authority in the appeal statute that Judge Northcutt referred to in the prior case doesn't give him the power to raise these issues. But the trial court summarily denied that motion for rehearing. In the briefing, I expected that the property appraiser would try to argue that the Value Adjustment Board was somehow factually wrong when it tried to explain that a business that repairs huge vessels using a 500-foot dry dock moored in several berths at the port fulfilled a maritime purpose. But instead of arguing we weren't maritime, he argued that this case was all about the governmental versus governmental proprietary test created by the courts to test the constitutionality of the statute. But again, he avoided, even in his brief, saying unconstitutional, and even in his brief, he didn't cite the controlling Turner case to this court. We brought it up in the reply brief. Now, it's a little bit helpful to know the history of how those two governmental tests were created, because they always are argued in all of these cases. But the dichotomy was created by Justice Sundberg in the Williams case. And that arose because after the amendments to the Constitution in 1968, the legislature passed practically a rewrite of the tax code in 1971. And when they did that, they eliminated pre-existing exemptions that favored practically everybody on Santa Rosa Island. Everybody on the island leased their property from the government. So homes and gas stations and restaurants, the whole 9 yards, was tax exempt. And they wanted to keep that. And the Supreme Court in Williams held that the legislature had validly enacted a statute, had the power to do so, and that statute had eliminated the pre-existing exemptions. So that's not what we have here. And then the language about administration of some phase of government is actually a definition taken from Black's dictionary that is cited as a helpful language in one of the Sebring racetrack cases. But again, the Sebring cases were before 1999. And so the property appraiser then was allowed to argue that the statute was unconstitutional. He couldn't have done that 3 or 4 years later after Judge Fulmer's opinion in the Turner case. So despite his initial pleadings that never raised constitutionality, this case has become a constitutional case under Turner, and this court can simply reverse because the property appraiser is actually challenging the constitutionality of a subsection in disobedience of the clear holdings of this court in Turner and in Fuchs. Now, it's not just the courts that have said this, because over the last 50 years, the legislature has done a number of things, primarily to expand the powers of the value adjustment boards to place a stronger buffer between the property owners and what was historically the immense power of property appraisers. In section 196.199 subparts 5 and 2, those require that the VAB establish the government exemption. If it is granted by the VAB on a challenge, by the way, by the property appraiser, the application is filed on the standard exemption form. It's not the DOR or someone else. It's the property appraiser who objects. In this case, he objected both against the Port Authority and Gulf Marine. But when they do that, it is valid for the term of the lease, according to the statute. And moreover, it's valid as to all other interests in the leased property shall also be exempt from ad valorem taxation. So to answer your question, if the VAB says that the lease is exempt, then also for at least the term of the lease, or unless the property usage changes, the exemption remains both for the real property and the lease.
Well, that's the question. Is there a difference between the leasehold interest, which is, I think, is itself, which is taxed as an intangible, is it not? versus the underlying property, which is what we're dealing with here in that respect, in terms of how long that determination is extant.
And admittedly, the legislature's bounced back and forth about whether they send one or the other. But now we know.
And they haven't always cleaned up the statutes when they do.
Yes.
So
now we know that it is the porch property and our lease. But what you need to understand is that they never created some statute about applying for an exemption for intangibles.
no, okay.
So under it's
So all of this statutory framework necessarily involves the dirt.
right. If you look at section 196, 193, 5B, I believe, excuse me, actually just the whole thing is the application for exemptions. And it is designed primarily, by the way, for the third sentence of Article Section 7, Section 3 about charitables and the like. But the forms they use have a other box. And if you have a governmental exemption, that's where you put your governmental thing. So, and then you don't file that. You might think since it's intangible tax payable to the state, you'd file it in Tallahassee with DOR or somebody. No, you file it just like you file it anyplace else with a property appraiser. And it's the property appraiser that's statutorily told to either approve it or disapprove it. And when he disapproves it, the challenge goes to the value adjustment board. It doesn't go to some administrative.
It's funny when you and this is just as an aside, I noted that the VAB notice of its final decision is on a DOR promulgated form.
They create the form for all the VABs to use of this thing. So it is very clear from reading these statutes in context that he's put in charge of managing both of these things. And when he loses in front of the VAB, it applies not just to the leasehold, but it applies to all other interests in the lease property, which is what the Tampa Port Authority is. So, but then it goes on and says that if the property owner loses, he can challenge it in court. But it can't, there's no provision here to disestablish it for the property appraiser. So that means that he has to jump to his right of review under 194.061(1)B that says appeal, but gives this sort of weird review process.
Well, and the bottom of the statute also says it'll be de novo.
Right.
So,
and so,
you know, and we do de novo review in appeals, but typically an appeal is not across the board de novo.
And so he files a complaint essentially in circuit court and says it doesn't fit the statute. And it's only later on that he says, oh, and really it's unconstitutional. But
well, actually his complaint cites the Constitution.
I went back and looked, but it doesn't affirmatively allege anything on that. The fact
it says it violates this provision, the specific provision of the Constitution. I went back and looked because the other guy said it wasn't adequately alleged. So I went back and read the complaints and they cite chapter and verse of the Constitution. They say this VAB decision violates.
But then they go on to say what Gulf Marine does, and then it doesn't fit the exemption. They never say, although they refer to the Constitution, they're not alleging it's unconstitutional.
No, they allege. What they do is they allege essentially the violation of the Constitution, and they say what Gulf Marine is doing doesn't fit.
Well, if that's what they do,
we're arguing about angels on the head of a pin. I get it.
Because under the review statute, the one thing they're not allowed to do is accept nothing herein shall authorize the property appraiser to institute any suit to challenge the validity of any portion of any duly enacted legislative act of this state. So if that's what he says he did, having lost Turner, he knows full well he cannot do that. And so we believed we were trying to prove up the language of the text of the statute. And the statute—
Isn't the question of governmental purpose a factual question?
It is when you're challenging the constitutionality of the statute, yes.
But if their position, if the property appraiser's position is that running a port does not necessarily require a shipyard for repair and maintenance, and and I'm not saying that's a winning argument or not, but if that's their position, then isn't that a determination by the VAB and perhaps for review by a court as to whether in fact the services are governmental services?
If you read the VAB's order, which is a couple pages of fine print long, but you really need to read it, they just flat out reject their ability to go to governmental, and they say.
But the question, but the VAB decision is not binding, right? Was not binding on the circuit court. Its findings of fact were not binding on the circuit court because this is a de novo proceeding.
Right, but
so basically, you're starting from scratch.
Right. So unless you're deciding that governmental has now become, after Turner, something that's incorporated into the statutes when it wasn't in Turner, this is Turner all over again. But if we go to governmental, Mr. Klug, whose deposition is in there from the Port Authority, says, we've got a big port. It's a huge port. We're bringing in large amounts of material, including oil. We only have 5 to 6 days worth of storage in this region of Florida, and half the oil is coming in and out of our port. We have to keep it open during times of when the weather's good, and we have to keep it open in times when the weather's bad. And it is essential to our operation that we be able to repair ships because we've got to get them in and out of our port. So it's his position, and the property appraiser has never really opposed this, that they can run this kind of operation. Now, the problem is this kind of operation is capital intense, not just leased land, but you've got these huge dry docks that can lift up 600-foot long ships. So
you're into your rebuttal time, Mr. Altenberg. Okay. So proceed as you wish.
I will, and I want to do one last thing very quickly. Then is even before all this took place, he had to file a notice of disapproval, which he did, in which he only says that his objection is that after his physical inspection of a marine port, he can't tell whether this is marine activity, but that it's for proprietary purposes. Well, that's not a statutory basis for him to deny.
But isn't that, again, that's a VAB proceeding, that leads up to the VAB, and we are now in the circuit court on a de novo proceeding. I'm not sure that might be, evidence for the court to weigh, but I'm not sure that it's preclusive.
Well, the problem is that under section 1961935B, he has to give us a clear and unambiguous explanation of what he's doing. And under the Genesis Ministry case from the first, if he doesn't, the whole process is invalid. And here, if he had filed an objection saying that ship repair business is a marine activity at this port, but the statute is unconstitutional unless it's limited to activities that are functions or duties that relate to the administration of government or some element of sovereignty, the VAB would have denied it on the spot because he was raising a constitutional challenge rather than a statutory challenge. So
we're not in the VAB anymore, and we are not reviewing the VAB, and what the VAB did or did not do really has no weight, does it?
Well, except that he has to go first through those administrative steps before he comes to any one of these courts. And Genesis.
Well, did you in your responses and your pleadings below allege that the VAB determination was in any way that
yes,
void?
Yes, we did.
Okay.
We challenged this. So
all right.
I'm going to save the rest of my time for rebuttal. Thank you very much.
Yeah. What little bit there is. No, I'm teasing. Okay. All right. You're up, Mr. Shepard.
I think I'll address the positions of the Gulf Marine first. I find it amazing that Gulf Marine is trying to discern the intent of the property appraiser. At no point did they sort of, go in and say, what were you guys thinking at that time? They really should have looked at the property appraiser's actions. There's no question that the property appraiser is not challenging the constitutionality of that statute because we have approved exemptions under that specific statutory section to other entities in the port. So to say that we're challenging the constitutionality of the statute, that would have been we deny everybody at the port across the board. The fact of the matter is there are many, many, many parcels of property at the port that are still exempt. So That's simply not the case. The idea that this is a leasehold case is utterly incorrect. The Department of Revenue approves leaseholds. You apply to the Department of Revenue, and the Department of Revenue actually has a department that reviews your leaseholds and approves or denies them. I've spoke to those folks. There are hundreds and hundreds of leaseholds of government property in Hillsborough County. This office has never addressed one, except in one instance where there were no rental payments. And in that case, if there's no rent payments, then the leasehold actually is dealt with the property appraiser. But otherwise, besides that one instance back in the 90s, this office has never, ever, ever dealt with a leasehold interest issue. It's all done by the DOR.
And if I looking at your complaint, it seemed to me, I don't recall whether, as I sit here now, you alleged what the provisions of the lease were as far as the use goes. What you did seem to allege was what Gulf Marine claimed was its actual use of the property. Is that correct? And so that goes to your argument that you weren't taxing a leasehold. You weren't describing the lease.
Yeah. The only reason we put the lease in there is to say this is what Gulf Marine and the Port Authority say they're doing here. It was just to establish the facts of
I get
what's
it.
happening, what happens at a shipyard. So,
Mr. Shepherd, the statute specifically identifies port operations as governmental. So is it the property appraiser's position that a shipyard that, to the extent it provides repairs and maintenance, that cannot be a governmental purpose?
if this were maintaining vessels used by the Port Authority, maybe this would fall into some sort of gray area, and we'd look at that, and if that's exclusively what they did, maybe we'd have to consider that. But the fact of the matter is, these guys are a proprietary business. They're in business to make money. Port authorities do not operate these type of entities, and they're not required by the law. These guys.
Well, I mean, I suppose the question is, and again, there's a lot of this in these related statutes and case law, you know, to say something is governmental might be useful in one context and not in another. So for instance, the Port Authority is not able to engage in other than a governmental, you know, action that has a governmental purpose. You know, it can't go out theoretically and just decide it wants to enter into the automaking business. You know, it's confined. So, you know, on the other hand, so if the legislature, and I'm spitballing here, frankly, but if the government, if the statute says, yeah, this is a governmental purpose, this is an essential governmental purpose. So does that necessarily mean it satisfies the governmental versus governmental proprietary dichotomy? Or does it do away with the necessity of looking at that? And that's, I think, the issue. That's the issue that Mr. Altenberg has raised.
Right. So it's what Gulf Marine is asking us to do today is completely ignore judicial decisions. They want to embrace judicial decisions when it helps them, but in this case, they don't want to look at any of those.
But you,
so how do you respond to his reliance on Turner versus Aviation Authority?
In that case, it was my case. We actually put in the complaint that the statute was unconstitutional. We lost that case. We lost it outright because that's at that point what we challenged, and we thought across the board. Actually, the decision was already out there, and so we embraced that. It was working its way up, so we embraced that. But look, we challenged the constitution of the statute. It was in the complaint.
I'm going to go back to what you said a moment ago, that the shipyard repair services cannot be part of the governmental use of the property, at least not unless it was the port's own ships. But is there any witness that testified to support your position? Because my recollection is the testimony was actually to the contrary, that in fact, these exact services would be governmental if performed by the Port Authority.
Yeah, I don't think that's the case. I think they twisted up.
I'm sitting here reading the deposition. Yes. Could it be done by the government itself? It could.
Yes, I think they twisted up Miss Martinez there. She was a little.
Well, we're stuck with what Miss Martinez testified, aren't we?
Pardon?
She testified the way she testified. You don't get to recharacterize what she really meant.
Well,
Except that
You
was,
know.
she was a hypothetical question that does
well,
not.
she was a fact witness, not a, that we decide the law. And I think the question,
I understand that,
the
Judge
issue
Martin.
that question goes to is, okay, you have governmental, and governmental proprietary. All of it is something that the government can do. The
That's
question
correct.
is whether it's something that in terms of the definitions of governmental versus governmental proprietary, it has to do, for instance, with the administration of the governmental purpose.
Well, Mr. Shepherd, maybe.
But there is a statute that says if it's something the government may do, it's exempt, correct?
Mr. Shepherd, maybe you can help me with this. Was there any evidence presented that these services were not services that are part of the governmental function? That's part one. And part two, was there any testimony that if the Port Authority performed these, they in fact would not be exempt from taxation?
No, if the Port Authority provided those services, actually, it's a different analysis. Ironically, under the statutes and under the court cases, if the government performs the function itself, they get a little more flexibility. So I wouldn't want to presuppose today that the situation is not before us. So I don't know how we would look at that if the port themselves was doing it. But the fact is that no ports do this, and only 2 ports have this operation here. It's not mandated by any law. And if you look at the Ports Enabling Act, this sort of, projects, any project we do falls under maritime. Well, I don't know if any of y'all have been out to that Sparkman's Wharf Entertainment Center. That's on Port Authority property. So if you're defining it as, hey, if it's a project under our Enabling Act, then it's exempt. Well, now you're exempting an entertainment facility, restaurants and bars.
Well, and that's where the factual questions come into play, don't they? I mean, Judge Northcutt has suggested, well, is this a legal analysis or a factual analysis? But don't the factual predicates that are presented to the court lead to a conclusion of law, which is it exempt or is it not exempt? Is it governmental, or is it not?
Yes, look, there's no question about what happens at Gulf Marine. There's no question.
Facts on the ground, what it is they're doing.
There's no question as to what it is they're doing. The question is, does that fit into a governmental category? Does it fall into a governmental proprietary category? And if you look at actually this governmental proprietary case came from another different Supreme Court case back in 1953, that Daly versus Stokel. And here's what they said. This is really the farthest back case I could find in Florida. They said, we understand the test of a proprietary power to be determined by whether or not the agents of the city act and contract for the benefit and welfare of its people. Any contract, in other words, that redounds to the public or individual advantage and welfare of the city of the people is proprietary. So yes, does Gulf Marine create a benefit for people in the shipyard and people building ships? 100% it does, but that's proprietary. The sentence continues. While a governmental function, as the term implies, has to do with the administration of some phase of government, that is to say, dispensing or exercising some element of sovereignty. And clearly, repairing ships and repairing hulls does not have anything to do with some phase of government or some element of sovereignty. And that's where this comes from. That's where the Supreme Court sort of pulled this out and applied it in the property tax context. And when you look at that definition, the government can do a lot of things. There's very few things the government can't do, but those are proprietary in nature. When you get to an element of sovereignty, the things that are happening right here, the things that happen in the building I'm in, the things that happen in the building you're in the courthouses, that's an element of sovereignty. And it's really quite easy to distinguish. This is not even a gray area case. There are some interesting cases out there now with, government's getting more involved in things or less involved in things where it's changing. It used to be a strict government thing and now it's become a private sector thing or vice versa. But this is not a gray area. This is quite clear. These Gulf Marine competes with other shipyards, not only in the Port Authority, but around Florida. So the Port Authority's Enabling Act does not provide the exemption. It actually says subject to constitutional and statutory limitations. And this court and many others have applied this governmental proprietary test for a long period of time in this very subsection of this very statute. It's a little ironic to say that all the direction that the courts have given this office and the other property appraisers' offices across the state for the last 50 years should be ignored of this very subsection. Maybe if it was a different statutory section. Okay. So there are plenty of cases out there already that discuss shipyards and what they're doing. You have this Todd Shipyards case and Weehawken versus Weehawken, this the New Jersey case. They found clearly doesn't prove a government purpose. You have this bond case out of Florida, State versus Jacksonville Port Authority. Bond case is much more flexible, right? You can do something for a bond case and it's considered to be a public or government purpose, but that doesn't meet the criteria of the exemption for property taxes. And you have Page versus Fernandina Beach, an aircraft repair facility. What's the difference between an aircraft repair facility falling under the airport definition, because that's also part of the statute, airport uses, and Gulf Marine falling under a port authority or maritime use. If the aircraft repair facility is taxable, it seems to me that this is reasonably arguable. Here's where Gulf Marine gets it wrong. In their reply brief, they say that the test is when a function can lawfully be performed or provided by the government. It is constitutional to provide an exemption when that function is performed by the for-profit lessee. That's out of their reply brief. That's simply not the law. The law is it a sovereign, an element of sovereignty? Let me address the denial notice. As you know, our initial argument is that this does not apply to these types of exemptions. This statute quite clearly in the bill summary says this is for nonprofits. And we have a conflict because we have another specific exemption statute, 196-0116A, that also talks about denial notices. Plus we have about 4 others that specifically address homestead exemptions or other exemptions. So where does the property appraiser go here? Which one does he apply? I think you have to look at the bill summary for the property appraiser to say, and by the way, we have hundreds and hundreds and hundreds and hundreds and hundreds of denial notices we put out every year. So it's a challenge. And this is an issue, along with the exemption issue, that's an issue statewide. All the property appraisers are sort of waiting to figure out where this denial notice goes. I did point out that this court in Baldwin versus Enriquez, that was the other issue in that case, that the court said we affirmed the other issue without comment. The trial court thought that the denial notice was okay. And the important thing about the denial notice statute is this. The denial notice statute says at the end of the day, the criteria is, would a reasonable person understand what they were being denied for? In this case, there was absolutely no question at the VAB. At no time did Gulf Marine come in during the Value Adjustment Board and say, why are we here? We don't understand why we've been denied. Is it the ownership? Is it the use? What is it? They made their legal arguments right there from the get-go on the use, the same arguments they're bringing forward today. It was only later as a sort of strategy. They said, oh, let's see if we can hang our hat on this statute. Finally, we're talking about exemptions here. These statutes have to be construed strictly against granting an exemption, whereas a normal tax statute is granted and is interpreted in favor of the taxpayer. Exemptions are strictly construed. I find it hard to believe that someone could apply for an exemption on a piece of property, let's say homestead. They don't own the property, they don't live there, and because the property appraiser doesn't quite get the denial notice right, that they get a homestead exemption. That's contrary to the Constitution. That's contrary to the idea that you have to apply strict construction. We think the denial notice, although simple, there's only a very small box. We think it covers all the requirements, of the statute. I think we already talked about the leasehold interest idea there. There's no question since 1980, leasehold interests are taxed as an intangible. It's a contract right. It's not the section of the fee simple interest, that's the part of the fee simple interest. It's not taxed as real estate whatsoever. It's taxed as a contractual right. And that's how leasehold. So therefore, that statute 196.199 subsection 5 has no application. That statute says leasehold interests in there. This office has never addressed the leasehold interest ever in my 25 years here, except for one instance with the old Tampa Stadium when the Bucks weren't paying on the lease. Beyond that, there was an issue with the subject matter jurisdiction. I think on Judge Northcutt, you already addressed that. The complaint lays out that we think that the VAB's decision violated the statute and violated the Constitution, as interpreted by this court and the Supreme Court and other courts in this state for the last 50 years. I think for me, that about covers it.
Thank you much, Mr. Shepherd.
Thank you.
Mr. Altenburn, I got you down for 3 minutes.
Okay. He claims that he doesn't cover leasehold interests, but section 199 or 196.199, which is all the government property exemptions, when it gets to subsection 5, says leasehold interests in government property shall not be exempt pursuant to subsections unless an application for exemption has been filed on or before March 4th with the property appraiser. The property appraiser shall review the application, make findings, and present it to the Value Adjustment Board. So he says he doesn't have anything to do with leasehold interests, but the statute says he does, and that's what he did here. He filed a.
So are you suggesting, Mr. Altenburn, that for purposes of the appeal to the circuit court, the taxpayer was the lessee?
The leasehold interest, I believe the taxpayer legally is the department, or the property, excuse me, I'll get this right, the Tampa Port Authority. But obviously we have an obligation to pay or reimburse, so we have an interest in that. But as I read the statute, we had to file this thing there. But one way or the other, if you actually believe, by the way, he says that all these cases have applied these standards to similar cases. Well, they did it to hold statutes unconstitutional as applied. In Turner versus HCAA, the argument was that as applied to a Yankee stadium, the exemption didn't work. And this court held that he couldn't raise that argument. Now, admittedly, if you had a stadium on a lease that was used only for high school games, because we built it for all the high schools, that would probably still be exempt under the statute. But as applied, it wasn't there. And he's making the same as applied argument here that he made in Turner. As he says, I just didn't say it was unconstitutional. That's the change he's made. He's got no standing to bring this from the beginning. But if you want to get to the governmental, the proof was from the Port Authority, not that, they don't give exemptions to the parking lot for use for cars coming off ships, because that's not essential to them. They probably don't give it to Sparksman's Wharf. I really don't know. But the people who do the unloading of the ships, load and unload the ships with all their materials for profit, they are exempt. And the Port Authority takes the position that if they're going to keep a port open safely, when things hit the bridge and everything else that happens there, they need to have a full service marine repair facility. And that is what Gulf Marine is. It's the one that can handle the 600-foot oil vessels. So even if you jump to the constitutional analysis of governmental propriety, this isn't somebody that language came out of Williams, and where the grocery stores and things were purely proprietary and for profit. There are lots of people who make some money who have valid exemptions from the government. The question is, are they doing something that is governmental? And the Port Authority
That's your 3 minutes.
Yeah, to the position that this is governmental. So I submit that under Turner and under the applicable statutes, that this needs to be reversed. And And he is right. All the other property appraisers are looking at this, and you'll hear another case from him next month where he wants to use this as precedent because he wants you to add the functions or duties that relate to the administration of some phase of government into the statute when it's not there. So thank you very much.
Thank you both very much. Well argued case. In